Mike Tigar is my next guest name. There are certain limitations, I should explain, about what can be said on television in regard to pending litigation. That means trials that are coming up or in progress. And so we have to, I guess, be careful on this, but my guest is a lawyer. He's Mike Tigar. He's a professor of law at UCLA, and he's an American Civil Liberties Union attorney, and he's representing the defense in a pending trial, the one we were talking about, termed the Seattle Conspiracy Trial. And conspiracy is a frightening word. I think it frightens most people, and better not to fear it, but to understand something about it. Here to talk a bit about conspiracy and what it means is Mike Tigar. Welcome, There are no chicks on this show tonight. Wait a minute, I must get serious. Have you, I mentioned that I had not heard of the Seattle Conspiracy, and can you give us now the facts that we should have without prejudicing the case?
Well, I think I can. The indictment in the Seattle case, which is a matter of public record, charges 8 young people with conspiring to inflict damage on the federal courthouse in Seattle.
Yeah.
The indictment does not charge that any of them did any act of violence, merely that they made speeches saying how bad the courts were, speeches in protest against Judge Hoffman's actions in Chicago, and organized a demonstration to take place around the courthouse. In addition to that, the same law that was involved in the Chicago case, the Rep. Brown Anti-Riot Act, is also figures in the indictment in that 5 of these defendants are charged, 4 of them with crossing state lines with intent to incite a riot, and 1 with making a long-distance telephone call with the intent to incite a riot.
What does that mean? I mean, that sounds, it sounds so easy to get into a conspiracy charge, the way you hear about it. What, have I been in one without knowing it?
Well, I don't know. If John Mitchell and Spiro Agnew keep on, the likelihood is very great. And, I mean, we welcome...
Well...
Put it this way. Historically, conspiracy means an agreement to commit a crime. If you and I agree to do something against the law but don't do it, we're guilty of a conspiracy.
Whether or not we do it.
Whether or not we do it.
If we agree
Therefore,
to do
conspiracy deals with the content of men's minds, with speech, with association, with publication. And historically in this country, its first and most infamous use was to smash a cordwainers' strike in Philadelphia in the 1820s among workers who'd gotten together to try to get their wages raised. Conspiracy prosecutions were also used against the abolitionist movement, against the women's suffrage movement, against the labor movement, and then in the 50s, as McCarthyism began to grip the country, it was used against the American left. And it is today the principal weapon in the legal arsenal of Attorney General Mitchell in attempting to smash the movement for change, because it's so very easy to prove a conspiracy.
Well, when does it become serious? I mean, if you and I conspire to jaywalk, it probably no one would bother us. And as you go up the level of things that you conspire to do...
In California last year, a group of young men were charged with, and this is a case that's over now, so we can talk about it, charged with conspiring to commit the offense of disorderly conduct. That is to say, if you agree in California to do disorderly conduct, that's a felony. If you do it, that's just a misdemeanor. Now, fortunately, these young men were acquitted.
You're not kidding me, are you?
No, it's People versus Bardicke, a case tried by Charles Gary, who's now attorney for Bobby Seale, in which he fortunately secured an acquittal.
If you conspire, it is not as, and don't do it, the results are more serious than if you conspire and do it in some instances.
That's right.
It's very, very strange.
The Anti-Riot Act is a different thing, though. The Anti-Riot Act is the Rep. Brown Act, which is the...
That's right.
The Anti-Riot... That's newer, isn't it?
That's 1968.
Yes, that sprung full-blown from the brow of Mendel Rivers and his associates in 1968 as a result of the ghetto riots. The theory of the act, and it's part of the Civil Rights Act of '68, was that black people in the United States would not know that they live under intolerable conditions and would not be having insurrections in the ghetto, were it not for people like Rathbone traveling from state to state and telling them just how bad off they were. And so it, as a statute in conception, it's an affront to the intelligence of the American people. As a weapon in the hands of the government, it's very dangerous indeed.
Is there a sense in which you are well, I don't know what the legal term is, but you're putting motives in the mouths of the people behind this, aren't you? I mean, someone would rise now and say you're leading the witness, if you, or something like that, if there were a witness. And if
Well, I'm not sure. I watched your program last night, and you had Richard Harris on. There's another Richard Harris who wrote a book about the Justice Department.
A different Richard Harris.
That's right. And that book was based on articles in the New Yorker that he'd written.
Yeah, I read that.
And if you read the statements of Richard Kleindienst, for example, about what this administration planned to do to the New Left from the time it installed Attorney General Mitchell, Deputy Attorney General Kleindienst, and so on, if you listen to John Mitchell say that this country is going so far to the right that you won't recognize it. I heard Donald talking about the War Measures Act in Canada. The same week the War Measures Act was imposed, and the government of Canada claimed power to search at will.
Yeah.
John Mitchell filed an affidavit in Seattle claiming the same power with respect to wiretaps. That is to say, in our case, as in the Chicago case, the government has claimed in an affidavit the power to impose a wiretap upon the telephone of any person who, in the Attorney General's absolute discretion, the Attorney General believes is engaged in subversive activities. And what that means is that the historic Fourth Amendment protections of privacy, the interposition of a disinterested judicial officer between the citizen and the police. That is to say, a judge. If you want to conduct a search, you have to get a warrant. John Mitchell claims that if you want to conduct a search of a subversive by tapping his telephone, that you needn't get a warrant. All you have to do is call up J. Edgar Hoover and tell him to put it on.
Now, at this time when there are so many dramatic headlines about violence and so forth, I assume that it's probably true that a majority of the country may be sympathetic to anything that they think will stop crime, and that's been presented as something that will stop crime. How do you convince them that that's less dramatic than a bombing? The idea of liberties being limited is not quite as pungent as, but what if they blow my store up or something like that? How do you...
That's true. Well, with respect to the general problem of crime, I know of no statement more eloquent than those that Ramsey Clark made here tonight. You deal with the social causes of crime.
Last night.
With respect, last night, yes. Did I say something else?
You said tonight.
Oh, sorry.
Sorry.
But with respect to so-called political crimes, that is, bombings and violent conduct, there are two important distinctions to make. The first is the distinction between conduct protected by the First Amendment and that which is not. That is to say, raucous speech, impolite speech, tendentious speech, that's protected by the Constitution. The second important thing, it seems to me, one has to say, is that there are many people in this country, beginning with the blacks in the ghettos, and now extending to poor whites, to young people, to Chicanos, Mexican Americans in the southwestern part of our country, who believe that this government no longer responds to their claims for justice. Under those circumstances, one sees frustration and anger. We've had it before. In the 1830s, a group of students at Lane Seminary in Chicago had their anti-slavery society disbanded, and they issued a call to burn the school down. The abolitionists disrupted trials under the Fugitive Slave Act, running into the courtroom and rescuing the defendants in some cases. The women suffragettes chained themselves to the front gates of the White House because their voices could not be heard. And unless we deal today with the things that young people are talking about, with a war in Asia that stands to sacrifice the lives of young men and the liberties of all of us, unless we deal with the problems of racism, poverty, sexism, by which I mean the exploitation of women, we're in for protest for a very long time to come.
I'd like to know what you think should be done about that after we get back from this message from our local stations. Mr. Tigar, let me ask you a quick question. Now, there were some people injured and there was some damage of property in the riot that resulted in the Seattle.
That's right. There were 87 arrests, as Donald mentioned earlier. None of the defendants in this case was among those arrested, even though most of them were at the scene. And none of the defendants in the conspiracy indictment is charged with having done a single act of violence. Their charge is rather conspiring, that is to say, agreeing to cause others to do acts of violence.
Well, I guess what I was saying was, is a demonstration in your mind in which people are injured or which property is destroyed a valid form of dissent?
Well, it certainly isn't constitutionally protected. Yeah. That's one thing. And as such, it's punishable under the criminal laws. What has happened in the streets of Chicago, I think that the violence, at least in the large demonstrations such as happened all around the country in the wake of Judge Hoffman's conduct in Chicago, is occasioned largely by the police. That is, you talk about injury to persons. The only people I know of who were injured in Seattle in the course of that demonstration were those such as the young woman who was dragged into an alley by the Seattle Police Force Tactical Squad and beaten until rescued by a medical team, and those who were otherwise harassed and hassled on their way to the courthouse. The damage to the courthouse, such as it was, involved the breaking of windows.
So it's clear, though, I mean, you would say that you think the conspiracy law and the anti-riot law are unjust, and is that the wrong word?
They're nonsensical. They're nonsensical. Can I give you an example? Do you have time for an example?
Yeah, if you have to, you'll get to one other point I'd like to get in. Go.
Sure.
Okay.
The Anti-Riot Act, I sometimes use this example. Imagine an old radical who has not been involved in politics since the time of Henry Wallace, and who one evening watching this program, Eye of Stone, let's say, is seized with an apocalyptic vision about revolutionary change and goes to his old Gestetner mimeograph and mimeographs up a pamphlet calling for a revolution. And let's suppose he takes 25 copies of it and mails it to his aunt in Kankakee, using the facilities of interstate commerce, that is, the mails. But his neighbor is an FBI agent and is watching. And so as his aunt totters up the steps of the post office to pick up her mail, and as she opens the manila envelope, she's observed. She pulls out the pamphlet and reads the first page, and in her quavering voice says, "Right on." Now that
Who is this woman?
man, she's one of your viewers. That man is guilty of violating the Rapp-Brown Act, and he and his aunt are guilty of conspiracy.
Well, then let's send them to jail. Wait a minute. The old crock. You don't think that Eye of Stone last night was inciting anyone to riot, do you? I mean, you wouldn't get that or inciting revolution from his remarks.
Well, I'm not sure.
Oh, you're not?
No, I certainly am not. When the truth gets out, you see.
Yeah.
The kinds of truths that Eye of Stone was telling last night. I think there's no telling what the people of this country are likely to do. So in that sense, maybe Eye of Stone was inciting the
Well, let's put it this way then.
last night.
The old lady and the man probably were harmless, but people have, in fact, in the history of man, met together to plan violence and conspiracy to kill, maim, or destroy. How should you deal with those people?
Well, time enough, Thomas Jefferson said, to try the act when it breaks out into the open. Conspiracy law involves you inevitably in attempting to fathom men's thoughts, including their political thoughts. And as such, it's a far too dangerous weapon to leave in the hands of government, even though you and I sitting here could imagine instances in which we'd like to see it used against our enemies. I do not think that...
Are you saying that there shouldn't be any conspiracy law of any kind?
I'm saying that there shouldn't be any conspiracy law. It just confers too great a procedural advantage on the prosecution. It makes it too easy to send principled and dedicated young people to jail. It makes it too easy to smash the movement for social change.
I wish we had more time to discuss that, because the idea that there's something that there shouldn't be any kind of law about is a startling concept to me.
Well, the conduct itself, that is to say, if it breaks out of the realm of agreement and into the realm of action, just as is the case in Canada, there are laws aplenty to deal with it. More than enough, probably. We're talking about the business of punishing agreement. And that, it seems to me, is dangerous.
I see. I guess. We have a message. We'll be right back. Well.